Good morning, everyone. I'm just going to wait for some of you guys to tune in. I don't have a lot of time today. I have about 15 minutes. So I'm just going to try and get to the topic right away. Good morning, Instagram, Facebook, YouTube. Let me introduce myself. My name is Aisha Chidole, and I'm an immigration attorney. I'm located in Atlanta, Georgia, but we have offices in Florida, Atlanta, and regardless of your location or state, we can assist you with your family immigration matter. As long as you want to immigrate to the United States, our phone number here is 407-995-6567. You can also send a WhatsApp message to 404-333-8751. Good morning, everyone. Today I want to talk about qualifying for a green card through VAWA if you are undocumented and you're the parent or child of a U.S. citizen, and then if you're the child of a green card holder as well. So, I know you guys hear me talk a lot about qualifying for VAWA as a spouse. So let's talk about children and parents. And before I get into it, for those of you joining for the first time who are probably wondering, well, what is VAWA? VAWA is a petition type that allows you to qualify for a green card if you've been in an abusive relationship. And so, that relationship can be one that is you and your spouse. It can also be one that is you and your parent or you and your child. So let's start with documentation and what qualifies you. So if you're a child and your parents are either U.S. citizens or green card holders, and you're under the age of 21, and one of your parents is abusive towards you, is cruel towards you, whether that's physically abusive, who's excessively cruel to you, who makes you deprives you from, let's say, things that you need as your necessity, has a form of punishment like starvation or Wi-Fi to do your schoolwork or transportation to get to school. And I'm just using different examples. Curses you out and says things to you that are demeaning, that affect you from an emotional and psychological standpoint. You can submit a VAWA petition. We see that happen a lot, especially in stepchild, step-parent relationship. Sometimes it does happen with parents as well, but this can happen also when you have a step-parent or, or your parent. In those instances, even if you entered the country without documentation, you crossed the border, you can be eligible to file for citizenship for a green card through VAWA, and showing that how all those things affected you. So similar to a marriage-based case, if you're able to show that the stuff that your parents have done to you or have said to you or have deprived you of, how those affect you. The same also applies for parents. If you entered into the country without papers, maybe you entered into the country and you had your child here, and then your child is a U.S. citizen and your child is over the age of 21, and your child has been abusive towards you. This one is sometimes very hard for parents to accept that they've gone through this, especially one because for a lot of times, for parents, it feels like, man, I failed as a parent, that my child is like this, or they just feel bad because, they just want to make sure that they're not painting their child in a bad light. But here's the thing, and what I would say to parents, the thing is, you can raise your children as best as you can, but you can't control their actions, once they become adults. Your children are your children and they'll do whatever they want to do. But you submitting a VAWA petition does not affect your child. It doesn't take your child's citizenship away from them. It doesn't put your child in any criminal danger, So if this is something that your child is doing and you qualify for, by all means, certainly call and submit a petition. And just in getting back to children for a second, so typically you want to submit this petition as a child before you turn 21. if let's say you're 21 and you just found out that you're eligible for this and you never submitted your VAWA petition, there is a limited window from 21 to 24 where you can do a late submission, but you have to show that your late submission is as a result of the abuse that you've experienced, and that's why you were not able to submit it. If you're over 21, obviously, most times you're not going to be able to do an adjustment of status at the same time as submitting your applications. As submitting your application, if you're under 21, you can do your adjustment of status. If you're a parent, you can do your adjustment of status. The reason why is because once you're over 21 as a child, you're no longer considered an immediate relative. You're now a family preference category. So really that's what it is. So the idea is the same with VAWA, with a VAWA based on marriage. The only difference is here you're a child or you're a parent. Again, it doesn't matter whether or not how you entered into the country. If you qualify, you qualify, whether you cross the border, whether you came in with a visa. If you qualify for it, you qualify for it. Okay, let me see what questions I have here, so that I can answer them. So Mood said, my 360 was approved August last year. I filed my I-360 and 485 together. I haven't heard from USCIS since my approval notice came to me. I never heard anything. What should I do? I was abused. Yeah, so then you might want to reach out to your field office. That's your local field office, to see if the VAWA unit has already sent your files over. If you work with a lawyer, your lawyer can also reach out to the VAWA unit to make sure that they've sent your files over. Okay. Okay, so you're saying that you were abused by an LPR. Yeah, so it shouldn't matter because your priority should be current. So that's fine if that's what you're saying. So Christina says, good morning. Can VAWA refer to the former marriage while filed for VAWA? I don't understand the question. If you can be a little bit more clear. All right, let's see on Instagram what we have here. Can your VAWA petition be approved if you have a pending removal proceeding case in immigration court? Yes, it can, and we've done it for many of our clients. Once your VAWA case is approved, though, you have to terminate your proceedings because you still will not be able to get a green card. You get deferred action, but you will not be able to get a green card until they terminate the proceedings. So you still have to file a termination of your removal case in order to get your green card. All right, let's see what other questions we have. Good morning, Everblast. So Raviv says, I need to know how to get an I-360 petition receipt number. By filing it. If you file for it and put in your address, usually it should be mailed to you. That's how you get it. Red Velvet says, I'd like to ask a question that's not related to the topic, if I may. Sure, you can ask a question. If it's something I can answer, I will. Kiara says, how long does it take to get approval for the I-130 petition for alien relative? The timeline varies. It depends on where your processing center, who's processing your case. For some people, that could be 8 months. For some people, it could be 2 months. For some people, it could be 12. For some people, it could be 15. So it really just depends on your processing center, but you can go online and check the USCIS case processing time, and you should sort of get an estimate of where you should be. Okay. Renee says, is it true I'll get a 10-year green card if I send in my documents a year now? Not really sure I understand what your question is, but if you're asking if you send in your documents after you've been married for a year, the answer is that it depends. You basically will get a 10-year green card if at the time of approval, you've been married for more than 2 years. So even if you've been married for 2 years and 1 day, you'll get a 10-year green card. If you've been married for less than 2 years, at the time of approval, you will get a 2-year conditional green card. If you are a VAWA applicant, regardless of whatever process, whatever time you've been married or divorced, you will get a 10-year green card. Um, um, do children go to the VAWA interview? Because I know a lot of parents would want their children to hear what they went through. Do you mean you know a lot of parents wouldn't want their children to know what they went through? Because I wouldn't want my kids to know if I went through something terrible. Um, so basically, if you're so VAWA is a self petition. What that means is it's you and you alone. So you are the only person going to the interview. Remember, guys, VAWA cases are approved without an interview. There's no interview for the VAWA portion of your interview. So you're never going to be talking about it. This is not the same with a conditional green card based on abuse. Based on abuse, you will be talking about it at your interview. VAWA cases, when you don't have a green card and you're trying to get a green card for the first time, those cases are approved without an interview. And then after the approval, you go to an interview for your 485. This interview does not talk about your abuse. It talks about what is in your 485. This interview is really for whoever has a 485. So there will not be any discussion on the abuse, or there's not supposed to be any discussion on it. Official, so I don't handle asylum cases, unfortunately, so I'm not going to be able to help you. So Red Velvet says, I entered the US on a work permit and I also have a tourist visa. I've been working and paying taxes for the last 6 years. Can I apply for a green card? No, you cannot apply for a green card based on how long you've been in the country, unfortunately. Even if you've been here for 20 years and working and paying 20 years, right now there's no rule that allows you to be eligible for a green card based on how long you've been in the country. I think my Instagram keeps cutting off. Let me know if you guys can see me on Instagram. How long is the VAWA process? VAWA takes 2 years, 2 years to 2.5 years. So whenever I give timelines, remember guys, sometimes it could be a little bit shorter, it could be longer, but most people, at least 80% of people will fall on the 2 year, 2.5 year timeline, okay? Nikia says, question, can a VAWA pending 765 and I-131 be expedited? Well, if you're able to show hardship or that you're a healthcare worker, you certainly can. Generally, right now, the rule for expedited is for renewals, if you're renewing your work permit, but you can certainly try based on hardship if you're able to prove that. But most initial work permits will go through the normal timeline that they're meant to go through, including biometrics. Christiana says, can they talk about the divorce of the former marriage before they approve the VAWA? Absolutely. Absolutely. Sometimes if your marriage is not legitimate, the previous marriage, they will not approve your VAWA case of the current marriage, even if you qualify. So you need to make sure that, you've dotted all your I's and checked all your T's. But basically with immigration, nothing is under the rug. Everything is brought to the surface, your previous marriages, your previous children, everything is brought to the table. The alias says, I have an I-130 pending for almost 3 months. I filed an I-360 for abuse. Is it going to last the 3 years, or may I change my? You cannot change an I-130 to an I-360 if your I-360 is based on abuse. The only time you can convert an I-130 to an I-360 is if you're a widow or widow. So again, it takes about 2 years to 2.5 years for you to go through the process. They're now going to say, okay, let's remove 3 months from the fact that you had the I-130 pending. I'm not sure what's going on with my phone right now. It's going in and out. Someone says, can I petition for VAWA because my 4-year-old son is emotionally draining me with his behavior? I don't know if you're being serious or not, Timmy, but no, you cannot. In order for you to petition for VAWA as a parent, your child has to be over the age of 21. A 4-year old is not considered to be abusive. A 4-year-old is a child, and all children, we all argue, are abusive to us, meaning they stress us out. I'm being funny, but meaning all children are stressful. And a child that's 4 years old is still going through, um, is still going through maturity. So no, your child has to be 21 for you to be able to file. But I don't know if you're being serious or not with that question. Kay Dover says, does a prima facie mean your vow has been approved? Absolutely not. It just means that you've met the minimum standards to be qualified. And because of that, there's certain benefits that are associated with it. But it doesn't mean that your VAWA case has been approved or will be approved. Okay? If a camera captures your estranged spouse suddenly appearing drunk in your house late at night when you're not at home, can you call the police on him? I can't answer that question. I don't work for law enforcement. I don't know what the requirements of breaking an entry in your state is. If for some people, spouses, if you are still together, it's not necessarily considered breaking an entry if they entered your house. So the best thing would be, yeah, if you feel that you need to call the cops at any time, or you feel like your life is at risk or endangered at any time, call the cops. If the cops feel that it's okay, the cops will tell you you can't press charges. If they feel you can press charges, then they'll tell you to press charges. But it's always best, anytime that you fear or risk anything, a lawyer cannot advise you on that. You should go to call 911, call the police, and let them be the ones handling it, because they're the ones that know what criminalities is. All right, so last question I'm answering. If your wife and baby mama kicks you out and try to wreck your green card process by calling and asking immigration for cancellation without informing you and refuse to sign a divorce, can you get qualified? Without an evaluation, it's hard to say. You can call and schedule a call so that we can see if you qualify. But have people qualified with their spouses doing that? Yes, but that there has to be something else that makes your spouse abusive, not just them calling to say something. If you're saying, let's say your wife is lying and making all those false accusations, those are things that could rise to the level of cruelty. So it's one that you should definitely get evaluated on to see if you qualify. You can call 407-995-6567. Akwata says, good morning, the best lawyer in the world. Thank you so much. Real Princess says, can I divorce my husband after getting my social and work permit? This man is tired. I can't tell you whether to divorce your spouse or not. Like, that's a personal decision. So I'm not really sure why you're asking that. I don't know if you're a VAWA applicant or not. But if the question is if divorcing your spouse affects you, if you submit a VAWA application already, the answer is no. But from a strategic standpoint, on a case-by-case basis, I usually will talk about, that with my own clients. Okay, guys, I got to jump off, but I'll be back on live on Friday at 1:30. And I hope you guys enjoy the rest of your week. Bye.